Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and we're continuing to talk about shareholder litigation. In our last episode, we broke down direct and derivative actions, and we talked about the requirements of standing and demand, which are like the entry tickets to a lawsuit. Today, we're moving past those gates. We're moving to discovery, the phase where you actually collect the evidence to support your claims and you start moving toward trial. Discovery is the fact-finding mission of litigation. It's where you turn suspicions into proof by requesting documents, asking questions, and building your story. In any lawsuit, both sides need a chance to see the facts, so there's no ambushes at trial. Discovery ensures transparency. You can ask the other party for relevant information, and they have to provide it unless there's a good reason not to. The rules, like Federal Rule of Civil Procedure 26, say the information must be relevant to your claims or defenses and proportional to the case's needs. They can't be too expensive or too burdensome, given the scope of the litigation. In shareholder litigation, discovery is crucial because the case often hinges on internal company secrets, like emails showing the board knew a problem but ignored it. And nowadays, we even have encrypted chat like Signal, which makes it more difficult to get some of this discovery. And without discovery, you'd have no way to prove misconduct. It's opening the company's filing cabinet to find the receipts for bad decisions. This process helps reduce agency costs by exposing managers as agents that have acted against shareholders, the principal's interests. How does discovery differ in direct versus derivative actions? In direct actions, you're suing for personal harm, like misleading disclosures. Discovery focuses on things that show how you were affected. So you'd look for company reports, stock price data, or expert analysis linking a lie to your loss. For example, if the company claimed a medical device had no risks, but there were internal memos warning of a potential deadly consequence, you'd request those memos to prove that they knew better. You'd send a request for production listing what you want. They respond in 30 days or object. If objection, you negotiate or ask the judge. We can't go through a whole course on discovery here. In fact, I think that is something worthy of a whole 3-credit course. And that's why I mentioned at the beginning of this is really an advanced discussion, assuming some knowledge of civil procedure. But those discovery matters are important here so you can prove that there was some material adverse event that directly impacted you. In a derivative action, again, you're suing for the company. So discovery has an early twist. Pre-suit inspection. Because you actually have to prove that the directors are not able to make an objective decision for the company. How would you prove that before the lawsuit? Well, Delaware has a solution, and the Model Business Corporations Act has some as well. But we have a pre-suit inspection rule in DGCL Section 220. DGCL Section 220 lets shareholders ask for books and records before filing a claim, but there's a condition. You need to have a proper purpose. It's like investigating potential wrongdoing and preparing for a future suit. Now, proper purpose isn't automatic either. You have to explain why, like I suspect board self-dealing based on public reports. Courts can review this to prevent fishing expeditions. The board doesn't have to grant every information request. And shareholders or plaintiffs' lawyers who represent classes of shareholders do go on some fishing expeditions where they're just hoping to find something or to harass the board into a settlement. So there is some policing against this. But if approved, you can get limited access, maybe board minutes or financials, and that might allow you to show with particularity that the board is not able to make the lawsuit happen, and you can claim demand futility. But to protect the company's secrets while allowing legitimate checks, there also might be safeguards on how that information is shared. If denied, you can appeal, but it's a key step to build a case. And once the suit starts, if you make it through the motion to dismiss, full discovery kicks in. So we then have rules that are similar to direct claims and, frankly, similar to civil procedure claims in general, where we are in discovery mode. The pre-suit information right is a really powerful tool for shareholders because it allows gathering facts even before officially filing a lawsuit, which can help meet high pleading standards required by courts. So as I mentioned, under DGCL 220, you could obtain board minutes that could evidence oversight failures. If a board only met for 25 minutes and ended up making a decision that was catastrophic, that might show that the board breaches duty of care in a Van Gorkum-like situation. In any event, using this can give you specific details needed to survive early motions to dismiss. Now, recent amendments like Senate Bill 21 from Delaware, which was recently passed, have refined these rights to balance access with protection against abuse. There are concerns, again, of these fishing expeditions. So, the new SB 21 clarifies what counts as a proper purpose and limits overly broad requests. It also clarifies the procedure for this pre suit information. So shareholders can still get crucial information to prove agency problems like managers holding risks from principals, but companies now have stronger and clearer grounds to push back whenever a request seems speculative. Again, the idea here is to avoid fishing expeditions. These changes reflect an ongoing effort to make litigation more efficient while addressing agency costs. By giving shareholders better pre-suit tools, it encourages well-founded suits and discourages weak ones. In practice, using Section 220 effectively can turn a vague suspicion into a solid complaint. For instance, discovering emails about ignored warnings helps plead futility in derivative cases by showing the entire board would be liable for a breach of the duty of care. But remember, SB 21 tightens and clarifies the reins, so the purpose statement must be precise and tied to potential wrongdoing. Overall, information rights like Section 220, while not part of the post motion to dismiss discovery process, are in fact a type of discovery because you're able to gain information in this way. And it's essential for leveling the playing field because it allows principals to uncover how agents might have cost them some value to the company. And they directly support the pleading standards requirements by providing the facts needed to show a plausible claim right from the start. Suppose there's a derivative suit because a board ignored cyber risks and there was a cyber attack. For pre-suit under Section 220, a shareholder could request minutes showing that there were discussions or a lack of discussions. If there are no minutes showing that the board cared about cyber risk prior to an attack, that alone could be a breach of the duty of care. Your proper purpose could be stock dropped after hacked. I suspect an oversight failure. And if granted, you will be able to obtain documents that could prove demand futility. For full discovery, you would request much more emails, reports, depositions, sworn interviews. You'd be able to get the board's time and attention in a deposition that you would schedule and ask questions like, did you warn anyone about this? And how long did you discuss it? So the information rights pretrial are much more limited, usually to books and records, than what you get during the discovery process. But again, a vital part of proving demand futility in derivative actions. Technology is transforming discovery. Traditionally, lawyers have reviewed boxes of papers by hand, literally tedious, expensive procedures where lawyers will fly to locations and spend days, weeks, or months combing through warehouses of paper. But now, tools like Relativity AI or Disco or other natural language processing algorithms can search documents for keywords or even patterns. It used to be a keyword search, but it's become much more sophisticated. Nowadays, you can take all of a company's information, even the paper can be scanned into OCR and processed by these AI systems that can flag the type of emails the lawyer should read. So it's a super fast reader who flags important parts or potentially important parts. And by the way, on the other side too, for defense, people are flagging things that are irrelevant that they won't disclose. And it's much easier now with AI, or things that are privileged, protected by attorney-client privilege can be detected by AI. But look, AI is not perfect. If you've ever used it, you might have noticed it can miss content. So humans have to verify this entire process. But it is transforming discovery. Of course, the other thing transforming discovery is the scale of information. Just try to imagine how many emails, text messages, notes Apple Corporation produces every day, every hour, every minute. Think of the terabytes and terabytes of data that exist today. And discovery can be very, very expensive because Satya Nadella's time is valuable. And if you get to spend 16 hours deposing him, that costs the company something too. So this is a big deal. And sometimes, because of the costs of discovery, parties are more willing to settle. So it's really important to have barriers, like we mentioned before, so that companies don't end up in positions where they are subject to fishing expeditions and rationally would choose to settle instead of spending all this time and money on discovery because there's just so much data these days. There's even new technology like blockchain, which is emerging, where each entry is locked and linked. And so we might be able to validate information that could be auditable and more publicly available. In litigation, this could prove that an email was sent on a date that was unaltered. In fact, when we collect certain information, we would run a hash function on it to show that that information has a certain quality that we can prove later we have the same information that we recovered when we retrieved it from a corporate executive's computer some months or years ago. So the actually idea of blockchain being a way to validate information is something that has been used in digital discovery for a long time. Now, again, we don't have the ability in this podcast to get into all the ins and outs of digital discovery. It's a course on its own that I recommend every litigator take, but it all applies here. And Delaware allows this for corporate records. So we can actually use blockchain to discover whether or not information is valid. So there's all sorts of new technologies to bring into the conversation. And obviously, big theme, a lot of new costs. So let's talk about the challenges of discovery. And I'm going to go back to cost. Discovery can eat up huge amounts of litigation expenses. Lawyers could bill hundreds, thousands, tens of thousands of hours reviewing this information. People are trying to use AI solutions to cut down time, but AI introduces its own kind of risk. For one thing, some are worried that the AI is not going to keep the information secret and secure in the same way that a lawyer reading a piece of paper in a warehouse would. Another issue is that AI makes mistakes. Another issue is that it hallucinates, invents things. We haven't solved all these problems yet, but AI is absolutely coming to discovery. The second objections come from claims like privilege or irrelevance, where we can protect certain information because a lawyer was involved with the discussion or the material should not be produced. And so someone needs to determine whether or not information is producible or whether it can be withheld. So in discovery, you might request all emails, but for one thing, you could say that's too broad. So then you might narrow it to all cyber related emails. So now the defendant has an obligation to look at all of their email and find all of the emails that are related to cyber incidents. And then on top of that, pull out anything that is irrelevant because it just mentioned it, like maybe an employee is going to Cyber Week. Well, that has nothing to do with their cyber risk, but there could be an email chain because someone was celebrating that an employee was speaking at an important event. That irrelevant information should be withheld. Or if a lawyer got involved with evaluating the cyber risk, we might be out of a privilege claim. So there's a lot of complexity here. If it gets stuck, there can be a motion to compel asking a judge to order production. And so this can get expensive because you might have some motions practice and there might be hearings required when parties dispute the scope of information available. And courts can limit requests to protect trade secrets. If the information is relevant, you might be able to obtain trade secrets under a protective order, but that also complicates how you can access and share it and how you can use it in litigation. So now we get into areas where we have entire litigations that are conducted under seal because we are dealing with trade secret information. This is all very complicated, and my intention here is not to give you a 3-credit course on electronic discovery, but to expose you to how this is going to play into our story of shareholder litigation. And I really want to impress upon you that it's very complicated, very expensive, and directly involves the use of a lot of novel technologies, which we don't have answers from courts around how they're going to be perceived. Like if we use AI to make a production and we accidentally produce some information that was privileged, will a court allow you to claw it back? Or if you produce trade secret information, are you able to claim protection over that trade secret? Or have you now had a disclosure of that information causing you to lose it? Or if you have blockchain based information, is that automatically validated or do you need independent validation? And how do we verify that the information is in fact real and not either hallucinated or otherwise fabricated? What kind of processes and hash functions can we use on data to ensure that the discovery results real information? And of course, we're dealing with the potential for waste and expense. And we have a game here where the cost of discovery may not be worth it. So parties might settle even if the claim has little merit. So it's very, very important that these claims don't make it past the pleading stage and are able to generate all this vast expense. Discovery is the foundation for trial. It allows you to prove your claims, but it can also be the end stage of litigation because of its expense. Bad discovery means a weak trial, but strong discovery can also mean incentives to settle. So when you're thinking about discovery, you start by listing what proves your claim and then request systematically the information you need. In the show notes, I'll put some best practices and some templates around some things to think about. Standing proves you can make the request, and demand shows you exhausted internal options first. When you make it past those gates, you have access to cost the company quite a lot of money by having a discovery event in a shareholder litigation. In our next episode, we're going to move to pretrial motions in direct actions. So this is a critical phase where we would use this discovered evidence to try to win or narrow the case early. But until then, this is Professor Seth C. Oranburg, and this has been Organized.